One of the questions that we get from time to time is, can I move out of the state of Wisconsin with my child?
Unless you have a court order doing otherwise, absolutely not. No, you can't. You're going to get yourself in an awful lot of trouble if you do so without first going through the proper process through the courts in order to authorize that move.
So what are some of the requirements around moving?
Well, the statute was actually updated in 2018, but I'll give you the long and short of it. The first is, it's a little bit of a mile marker. Even if you're in the state of Wisconsin, if you intend to move with the child more than 100 miles from that custodial parent, you're required under the new law to make a formal motion to relocate. If you move across state lines, you're automatically compelled to make that motion to relocate. The issue is really, one of practical consideration. And it's actually, the statute says 100 miles, but quite frankly, if you're intending to move further than, let's say, even 60 miles, you're probably going to fall in the same bucket, which is more than 60 miles for kids that are school age. It's really tough for two parents to share placement of that child in an equal fashion. So you're going to have to follow the process of the court, which includes making a formal motion. The other party gets the chance to object in writing. If so, there's going to be an initial hearing within 30 days of that motion. Almost automatically, a guardian ad litem in the best interest of the child is going to be appointed, and you're going to have to go through the process of a custody and placement conflicted case.
Why do the courts rule in that fashion as it relates to not allowing parents to move kind of really outside of a predetermined radius? So can you give me a little more context of kind of why the courts look at it that way?
It ultimately centers on, the notion of disruption, right? And there are two parties that are really going to be impacted by the disruption of a move of more than 100 miles. The first is the child, right? I mean, the courts have a certain paternal instinct where they have to look out for the best interest of the child. The circumstance of a child who grows up in a certain area, makes friends, gets involved on, very specific location, specific sports teams, or otherwise grows roots in that particular area, disrupting that child's life by moving them more than 100 miles away is basically starting that child in a brand new life. Got to make brand new friends, brand new school, brand new sports teams, brand new everything. That's entirely disruptive for the child. So the move has to be in the best interest of the child. There has to be something in it where either the present location doesn't make sense anymore for that child's life, or there's some kind of harm or present danger that moving that child is warranted. The other part is the practical consideration of a parent who's used to sharing placement of that child. More than 100 miles makes it almost impossible to share equal placement of a child. Again, simple math. If we're meeting in the middle, each of us is driving 50 miles to transport that child from one place to the other. So we're talking about, on average, a 2-hour round trip for every transition in exchange for that child. There's absolutely no way that child can go to the same school ever again. And quite frankly, it's pretty impossible that I'm going to be able to practice equal placement of that child if that child's in school, because that 2-hour round trip each way is just, it doesn't work in the real world.
If one of the parents actually objects to the move, because that would likely happen in one of these scenarios where someone's looking to move a pretty far distance away, what happens there?
So the steps are actually really clear. The first is there's going to be an initial hearing set. That hearing is going to be set within 30 days of the original motion being filed. That's statutory. That's required. One thing that's really important, and we tell parents all the time, you cannot move that child during or prior to that initial hearing. So you can't just file your motion up and move and hope that everything's going to be okay afterwards. That child has to stay in place until that initial hearing happens. At that initial hearing, there may be temporary orders or interim orders that are granted for the child to move, but there's going to have to be exceptional circumstances for that to happen. At that initial hearing, a guardian ad litem will be appointed then, and the guardian ad litem then has a 90-day window, generally, sometimes 120 days, in order to perform their study in the best interest of the child.
Thank you for watching this video. Please like, subscribe, and share. Your interaction with our content is greatly appreciated. Visit sterlinglawyers.com to learn more about our firm and meet our attorneys.